90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today's program is about arbitration, and especially the American Arbitration Association, one of the pioneers and one of the leaders in alternate dispute resolution. And our special guest is attorney Jeffrey T. Zaino, who's the vice president of the commercial division in the New York office of the American Arbitration Association. Jeffrey, welcome to Law You Should Know.
Thank you so much, Ken. Great to be here.
In these post-COVID times, arbitration and alternate dispute resolution are becoming buzzwords as we catch up and try to make the resolution of disputes in all types of disputes as painless as possible. But the American Arbitration Association has been one of the pioneers and one of the leaders in resolving disputes of all kinds, of all sizes, outside the court. So just tell us a little about the American Arbitration Association.
Sure, great. Thank you. Yes, the AAA has been around for a long time, 97 years we've been around. We came about in 1926, a year after the Federal Arbitration Act was enacted. Our legacy caseload in 1926 was labor. That was the only caseload we did back then. Now we've expanded tremendously since then. We do every type of caseload at the AAA ICDR. And we have 26 offices today at AAA. I'm based in New York City on 42nd Street, but we have an office also in Singapore, and we have over 600 employees at the AAA ICDR, and we do 500,000 cases a year. And like I said, we do cases in every area of the law. We do low dollar end cases and we do very high end cases at AAA ICDR. And we're very proud of the fact that we, in addition to doing arbitration cases and mediations, we educate the public. We're a not-for-profit organization, so we educate the public about ADR, and we also do elections for major unions because we're a neutral organization. So we're involved in a lot of things. We've changed dramatically since 1926, and I'm proud to be a part of this organization for, I hate to admit it, but 30 years. But I'm proud of that, but I hate to admit my age.
And the American Arbitration Association is still overseeing and resolving labor disputes all around the country.
We are. Every corner of the country, we're resolving labor disputes and employment disputes. And we also handle major union elections for the firefighters around the country, for the teachers, Chicago Teachers Union, New York Teachers Union, United Federation of Teachers, also the postal workers. So yes, we're heavily involved still in the labor area. That was our legacy caseload.
You're acting as a neutral. You have you're not showing any sides, any favors. And in resolving disputes, you're acting as a neutral. You take no sides. You want to just give each party or person their chance to be heard and have their disputes to be resolved by one person or a panel of arbitrators who are neutral as well.
Yeah, absolutely, Ken. We are a neutral organization. We live or die by that, and we've obviously lived for a long time being a neutral that is well respected around the world. During Storm Sandy, and a lot of us remember Storm Sandy in the Northeast of America, we were hired by the state of New York because of our not-for-profit neutral status. And they hired us to handle over 6,000 cases in New York and about 3,000 in New Jersey. And they hired us because we're a neutral organization and also a not-for-profit. Initially, a lot of people thought, the homeowners thought we were part of the state government, and they were a little bit concerned. But once they had their day in court, these are mediations. They met with mediators. We resolved a lot of disputes. We're really proud of that program that we did.
And Just to clarify for everyone out there, you're an alternative to going to court. You're an alternative to someone suing and being sued, and which is resolved by a jury, and the results are public, and you have to go through bureaucracy and a lot of procedural rules. It gets expensive, convoluted. It's a long process, and many people are not happy with it, and there's usually a winner and a loser. You provide privacy. Sometimes there's a win-win situation that evolves, and you can resolve and oversee these disputes with a minimum of time and a minimum of litigation expenses.
Absolutely. And that's time and cost are the big factors in arbitration. There's a study that was done by AAA and another organization called Micronomics. If you type in Google, Micronomics and arbitration, there was a study done a few years ago, about I think 5 years ago, comparing litigation with arbitration, and the time and cost factors are dramatic. But also, you mentioned the other areas that I love about arbitration in comparison to litigation: the flexibility. You have so much flexibility. The parties can work together and try to figure out the best way of resolving their dispute. If they're playing nice in the sandbox, you pick your decision maker. You don't do that in court. In court, you're assigned, as you know, Ken, you're assigned your judge, and you may not like him or her, and that may be a problem. Also, they're not experts in the field. Usually, they're probably, the judges are great. I'm not criticizing judges, but you're not going to get an engineer judge. You're not going to get an architect. If you go into arbitration, you can get any type of arbitrator you want. It's a lot different.
And they're also very busy. Judges in a traditional setting are very busy. They can't always provide time to listen to your dispute. They might do it in bits and pieces. You might have to wait on a long line. Here, the neutrals who are going to decide the case are devoting themselves to your case. They're going to listen to it whenever the parties are ready. The procedural rules are relatively simple, and the parties can even make it simpler. They can agree on a lot of things. And so that it proceeds at a much faster pace, and you control the setting. As you mentioned, you control the neutral. You control a lot of things.
Yes, you do.
And in court, you control very little.
Yeah, in court, you control very little. You're so right. And the time factor, the cost, usually in arbitration, a big complicated matter can take up to only 9 months. If you go into court, you're looking at a minimum of 2 years. And I'm being very conservative here when I say that. So there's a huge difference in the time and cost. And people say, well, arbitration, you're paying for your arbitrator. Well, then why? Again, it doesn't make sense. You go to the court, and you're not paying for your judge. So why is it less expensive? Well, it's the time factor. The time factor of dealing with this matter for 2, 3 years, 4 years in litigation, it has a big impact.
And you're paying for lawyers to go to court, for conferences, for hearings, and many times over years where things and a lot of these appearances may be a waste of time. So those things are dragging the case out, and they're costing you money over those 3 to 5 years. And then, of course, Absolutely. If you're not happy, there may be appeals. So you are paying for the mediator or arbitrator, but you're getting their undivided attention, you're getting their neutrality, and you're getting a speedy decision from them. Absolutely.
And then we saw during the pandemic, the court systems around the world shut down for about 3 months, 2 to 3 months. The ADR providers, like AAA, ICDR, and the other ADR providers, never shut down. We were able to keep on going, and we had the flexibility to use any virtual platform, and we did. We didn't just use Zoom. We used Microsoft Teams. We used whatever the client wanted. The flexibility was there. And the arbitrators, I was pleasantly surprised, Ken, when the pandemic hit in March of 2020. I was concerned. We have 6,000 arbitrators on our panel. And I was concerned that some of them may not, there may be a generational gap about the technology. There wasn't. It was so great to see us transition into the virtual world. And the court system took a long time to do that, 3 months. They were shut down. And I'm not criticizing the court system. I'm saying they had no choice. I mean, they're limited because of they're government agencies. They're limited on what they can do in comparison to private organizations like the AAA, ICDR, and other ADR providers.
You operate a user-friendly process. You have support staff who are designed, their goal is to help the users, the litigants, to use whatever technology, to follow the procedural rules, to make it user-friendly. The court has rules, and they expect you to follow them, and they're not necessarily going to give you advice or help in complying with those rules. Everyone's on their own.
Absolutely. And that's why I love about arbitration, that, you can deviate from any of our rules. We have set rules for every single area of the law, for construction, commercial, ICDR, international. The court system has their rules, and we have, the federal rules of procedure, evidence, all that kind of stuff. The court system has all their rules and procedures. You have to follow them, regardless of whether or not the two sides are agreeing to deviate.
And there can be very difficult consequences if you don't. Even if both parties want to relax them or agree on a lot of things, you have to follow their rules, and they can't really customize those rules for you. The rules are rules.
Yep. The rules are rules. And Ken, I'm pretty sure you know this, that sometimes, occasionally, the parties, if they're annoyed by the arbitrator, if the arbitrator is not doing what they think is the correct way, or they're limiting them in certain areas, they can remove the arbitrator together. I've seen that happen. You can't do that in the court system. That would never happen, where, the two parties can agree to say, we don't want this judge any longer.
Okay, we're gonna talk in a moment about the arbitration process, how it begins, and then some of the examples of different types of issues that can be arbitrated. But I'd like to remind our listeners that we're talking about the American Arbitration Association. Our guest is Jeffrey T. Zaino. He's a vice president of commercial division in New York. And as you've heard, the American Arbitration deals with all kinds of disputes all over the world. So, Jeffrey, sometimes there's a contract or agreement which provides for arbitration through the American Arbitration Association. Sometimes there's a contract that specifies any disputes resolved through arbitration without naming an organization. And sometimes people are ready to sue. But in any of those situations, the American Arbitration Association can assist the parties in resolving that dispute.
That's correct. And we do see some contracts where they don't name the AAA specifically. And then what we'll do is we'll accept the case, and we'll ask both parties if they agree, and we'll explain the process. And usually they end up agreeing. Where we have issues, where people criticize arbitration, is two areas in the contracts, is employment and consumer. But Ken, what I tell people all the time about those two areas, we're the good guys, the ADR providers. We do not write ourselves into contracts. People write us into contracts. We're in millions and millions of contracts around the world. They write us in. When they write us into a contract of adhesion, that's what employment is and consumer is. It's it's a forced arbitration clause. You can't, if you go into the AT&T store to get a phone, if you cross off the arbitration clause, they're not going to give you the phone. If you go for a new job in employment and they say there's an arbitration clause, you cross it off, you're not going to get the job. But what we did at AAA years ago in the 90s, we created the due process protocol for employment, and then we also then later on created it for consumer, leveling the playing field for these people. So where we get criticized is those two areas. The other areas we don't so much. I mean, B2B, people want to be in arbitration, but consumer and employment, I want your audience to realize the ADR providers are the good guys. We don't write ourselves into contracts. We try to make it as fair as possible. For example, in employment, if you file a case with AAA, the employer pays almost all the cost of the arbitration. Right. Consumer, same thing.
And you can discuss these issues with your attorney. I mean, there may be some exceptions to them. There's always exceptions in the law, but your point is well taken, and there may be exceptions. So let's talk about the arbitration process. You're involved in commercial division. So let's take commercial cases. What is that? What types of cases are considered commercial? What is the general process?
Sure. Well, the general process is most people file online. Most people have a contractual clause. I would say 98% of our cases we're a creature of contract. You wrote us into the contract. You said that you want to arbitrate a matter with the American Arbitration Association. So it's filed with the AAA. There's a filing fee. We have a sliding scale filing fee. Everything is transparent. Set filing fee based on the amount of your claim. So whatever your claim is, if it's a really high claim, it's a little bit more obviously than a smaller claim. So you file the case with the AAA ICDR, and then at that point, the AAA proceeds with communicating with both sides and talking to both sides about what type of arbitrator they would like. And we do that. We actually sit down with the parties and say, okay, what kind of arbitrator do you want for this matter? And we discuss that with the parties. And then the process usually moves really fast. I mean, we have within 24 hours of the case being filed with the AAA, we initiate it within 24 hours. And we assign a case manager, and we have hundreds of case managers around the country that deal with these matters. And the thing is, it's great to see the majority of our cases get done within 6 to 9 months. And that is so nice to see. And the process is the arbitrator is appointed by both sides. They agree either by a list. We send out a list of arbitrators, or we send them a link to our whole panel. We have 6,000 panelists, or we say to them, do you want to come to the table with an arbitrator? And with AAA ICDR, you can come to the table and say, listen, I don't want a AAA arbitrator. I want to use someone else. And you can do that. Okay. And some providers don't allow that, but AAA does allow that. Once the arbitrator is appointed, then we go through disclosures and we talk to the arbitrator. The arbitrator meets with the parties. We usually have, honestly, a minimum of 5 hearing days for really, really large cases.
So there's an initial meeting in most types of arbitrations where the arbitrator talks to the parties, just gets an idea of the lay of the land, what the dispute is about, how much time each party needs, what kind, and the attorneys, everyone kind of agrees on a schedule.
Absolutely. That's the preliminary hearing, and we have those for all of our cases where the arbitrator meets with them. They used to do it by phone. Now, because of the pandemic, they all do them by Zoom because they want to see counsel. They want to see what they look like and get a feel for counsel, and it's much better, I think. But yeah, they talk about the schedule and they talk about the cost. This is going to cost X amount. This is going to be 40 hours of my time, and they know the cost of the arbitrators, and because it's on their resumes. So all of that's laid out at the beginning, and we encourage counsel to bring their client to these. So that helps in some senses to maybe narrow some of the issues and say, oh, whoa, this case, we didn't think it would take 5 days. Maybe it can take 2 days, or we can talk about mediation, those kind of things.
And maybe there's only a few issues in dispute. Maybe the parties agree on some of the facts and some of the issues, and the arbitrator can spend their time on those issues that are still in dispute.
Without a doubt. And we see that. And the good arbitrators will suggest, hey, did you mediate? Did you try to mediate some of these issues to narrow some of the issues? Or do you want to do a simultaneous track where we will, AAA will mediate the case off to the side and we'll continue on with the arbitration process? I'm seeing that more and more now, Ken, where people really are embracing mediation.
And really, with the help of a trained facilitator, maybe you can agree on some of the issues. Maybe you can even agree on the resolution. So does that same person same neutral act as the mediator and the arbitrator? Great question.
That's a big debate now. It really is. Some do. And you have to sign an agreement that you had this person that heard your mediation or was your mediator, heard some confidential information, and now you like that person so much you're going to use him or her as your arbitrator. AAA normally is not too crazy about that, but if you don't caucus separately with each party and you do the mediation and together with both sides, I don't see it as a problem. If you say if both sides agree that, listen, we said some confidential information to the mediator, now we're going into arbitration to resolve some issues. It's fine. It's happening more and more. I'm seeing
because they both have faith in that mediator, that superpower, to be fair in making a decision.
No, absolutely, and I understand. Counsel has, they invested, they like this mediator, and they think, wow, he or she is probably going to be a great arbitrator in this matter to resolve the rest of the issues, and let's keep them. And so, I didn't see that in the past. 20 years ago, AAA was like, no, you can't do that. That's
but
not
both sides would have to agree on that.
Absolutely.
And if one side or a number of parties did not like the style or the attitude of that mediator, then they could at that point get an arbitrator and the dispute would be arbitrated.
Absolutely. And usually most cases, the majority of cases, it's a different mediator because we're trying to do a simultaneous track. I love the simultaneous track because it's going on when we're not stopping the arbitration process, the discovery process. We're doing that over here on one side, and then the other side we're doing the mediation.
And for the benefit of our listeners, the mediator is not going to make any decisions. They're going to huddle with each party or huddle with all of them together, go back and forth and try to work out an agreement that both parties can live with, maybe dealing with one issue at a time. The arbitrator is going to act like a judge and listen to the facts and render a decision.
That's correct. Yep, absolutely.
Let's talk about some of the other panels and types of cases that are resolved through the American Arbitration Association in New York and around the world?
Sure. We do a lot of high-profile cases because it's private, and not because it's a star chamber and people are trying to hide things. We get a lot of high-profile people, actors and actresses and musicians, because they just don't want to go to the courthouse to resolve a construction dispute. For example, we had a really well-known actress at our office right before the pandemic. Everyone on this podcast would know who she is. And she felt free to walk around our office. Now, if she was somewhere else in a courthouse, it was a basic construction dispute. It wasn't anything very salacious or anything like that. So we see those. We see high-profile cases. We see just basic business-to-business disputes for major companies like Microsoft and Yahoo. We get those kind of cases. And major pharmaceutical companies, we see those all the time. But a lot of them are, sometimes it's, really, a lot of cases we see are family businesses too lately. I've been seeing a lot of family businesses in New York. Elsewhere, we see a lot of technology cases, healthcare. Right now, our biggest caseload is healthcare. We're seeing a lot of healthcare cases coming in the commercial area. Technology is, I think, second. Financial services is third. So we're getting a lot of cases in all areas of the law.
I just want to remind our listeners again, we're talking with Jeffrey T. Zaino. He's an attorney and he's the vice president of the commercial division of the American Arbitration Association in the New York office. As he's mentioned, they have offices around the world and they handle all types of disputes. You're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. You also have different panels through American Arbitration that decide no-fault coverage and insurance coverage questions, and in some cases, damages for certain types of auto accidents. Can you explain a little about how those proceedings work?
Sure. Those are AAA oversees those in New York and one other state, and those are run by the state to some extent. I mean, we run the arbitrations and we do not select the panelists. The panelists are selected by the Department of Financial Services in New York. They select who's going to be on the panel. And these are full-time arbitrators. AAA then facilitates, helps the arbitrators. We provide them with a laptop. We provide hearing room space. We do the intake for the case issues, and we talk to the clients, and then we work with appointing the arbitrators. But it's a lot different than other areas of what we do at AAA, but it is a great program. I think our caseload there is about over 250 to 300,000 cases a year just in New York for no fault. Cases for car accidents and things like that.
And for the commercial disputes and the other types of disputes that you do administer, how can lawyers or perhaps other people qualified by their backgrounds to be arbitrators join your panels?
Sure. It's not easy. When I started at AAA a long time ago, we had 56,000 people on our panel, Ken. 56,000. Now we're down to 6,000 because we did a major purge and we up the requirements. So you have to have a minimum of 15 years of experience to get on the construction panel, ICDR, commercial. Now, when I say 15 years of experience, that does not mean arbitrating cases for 15 years as an arbitrator. It means you have industry experience and arbitrated cases as an advocate, okay, or as an industry expert. You've been involved in them somehow as an industry expert. For example, an accountant. An accountant has, seen some cases, was an expert witness. So we look at people for their industry experience background. And again, you have to have the 15 years of experience. And in New York, I'll give you an example. I only put on the New York panel probably about 6 to 8 people a year. That's it. Because we have 400 panelists, we're pretty covered in New York, but it's not an easy process to get on our panel. But once you get on our panel, it's a great thing. It really is.
And for some of your panels, is it if the person has industry experience but they're not a lawyer, is that acceptable?
It is, but it's a small percentage. I would say it's about more in construction. But overall, I would say maybe 6%, 7% are non-attorneys. It seems like the majority of people want attorneys. So if they're going to go into construction, they're going to want an architect that is also a lawyer. Commercial, maybe an accountant that's also a lawyer. It seems like the lawyers that are selecting arbitrators, the majority of them are, the ones that are selecting arbitrators, want people that are also lawyers, but have a lot of experience in certain industries.
And what about the labor panels resolving labor disputes? Are they sometimes not lawyers, or they're usually
Yes.
lawyers? Okay.
That's good point. That's a little different, and that's pretty hard to get on the labor panel. You have to be independent. You can't be working for a firm that represents either management or union. So that's a block for a lot of people, because you have to take that risk and say, okay, I'm going to become a labor arbitrator, and that's my only source of income. And you have to have 9 references. You have to have 3 references from union, 3 references from management, and 3 arbitrator references. So it's a challenging area, but it's a great area. And again, we do about, I would say in New York alone, we do about anywhere between 8,000 to 10,000 cases a year in labor.
You've told us about the history and the present reach of the American arbitration. What do you see happening in the future in terms of how arbitrations are handled, or different areas that will be subject to arbitration?
Sure. Well, I'm seeing it right now in New York, and my colleagues around the country are also seeing it, where, the pandemic affected a lot of things. I think mediation, a lot of people are going the virtual route. They're not going to come back to in person. Arbitration, we're going back to in person, but we're doing a lot of hybrid. Okay, we have cameras now installed in the hearing rooms. Also, the arbitrators and the counsel now expect to have in the rooms tons of visual things. They want screens. They got used to it during pandemic. So we're seeing that now more and more than ever. And we're seeing less paper. I mean, I used to see in my office at 42nd Street in Manhattan, I would see binders all over the place for hearings. People are now using tablets and multiple screens and that thing, even in person, not just at home. So it's changed. Things have changed.
Can you give us contact information of the website for the American Arbitration Association in case lawyers or consumers or business people want to learn more about their program? Absolutely.
Our webpage is filled with so much information. And you can file a case on our webpage. You can find out about any area of the law that I'm talking about and file for to be an arbitrator on our panel. www.adr.org. Real simple. And also, I'm pretty active on LinkedIn, Ken, as you may know. And every day I post something on LinkedIn. I'm going to post about this show tonight. And I put links to certain things. You're not going to see pictures of my kids. It's all about alternative dispute resolution and about programs that are being done, not just in my background, my backyard in New York, all over the world. I post about programs. So if you see something, on my LinkedIn page, you're interested, contact me.
And ADR is so important between governments, between different factions and countries, between countries, between international businesses. It's so important to commerce and in ensuring goodwill between countries and different worldwide commerce.
It so is, and it's so important. And I've seen it in my career grow tremendously. I mean, when I started at AAA, we were even close to 500,000 cases a year. It's growing, and it's a great thing, and it's saving a lot of money for people, and it really is a great process.
And it's very efficient. What else would you like everyone to know about ADR and about the AAA?
Well, just realize that the AAA is a not-for-profit, and I mentioned before that we're the good guys. We don't write ourselves into contracts. Just remember that we're accessible. Your local. We have offices all over the world. Please, if you have a question about any arbitrators, if it's not even a AAA case, we don't care. We're a not-for-profit that's out here to help the community understand ADR. So I talk to people all the time, even about non-AAA cases, to say, hey, listen, I know of that arbitrator or of her, and she's great, or I know of educational programs for you if you want to get into this field. That's what we're here for. Part of my job is not just getting cases in the door and appointing arbitrators. It's talking to the community like I am tonight with you. Thank you for this opportunity.
And the educational programs are also available at adr.org?
Yes, they are. We have a listing of programs, on our webpage, thousands of programs that we've been doing over the year. There's so many recordings there.
And it's important to get the word out to business people, to consumers, and even to lawyers and law students about ADR.
Without it, I speak at law schools probably 3 times a month because I see that's the pipeline. That's the future. These are people that are going to be filing. They're thinking litigation. When I went to law school, I thought litigation. Now I want the law students to think about an alternative to litigation. It's no longer really alternative. It's dispute resolution, because it's not really an alternative because we're getting so big.
Okay, I'd like to thank our guest, Jeffrey T. Zaino, the Vice President, Commercial Division in New York of the American Arbitration Association. If you missed any portion of the program and would like to tell someone else about it, just go to nccradio.org, and please join us next week at this same time for another program on Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York.